For the first time, I feel like I'm starting my true work to bring together the two loves of my life, science and law. And I want to do that with you because truthfully, none of us really know how law will face the rise of intelligent systems. We as a legal fraternity, we are all searching. We're all a little lost. But maybe together we can start finding our way, slowly, honestly, and humanly. So let's learn together. Let's ask questions that may scare us sometimes. Let us write, talk, think aloud, not to sound smart, but to stay awake. So welcome to the intelligent future of law, and thank you for being in my journey today as I take my first step back towards the stars along with the statutes. By the late 20th century, thinkers influenced by Marxism, post-structuralism, and feminism began questioning not just what law says, but how law shapes what we think is true or normal. Where the common law sought wisdom in experience and positivism sought certainty in system, critical legal thought asked who benefits from the way truth is defined in law. Power and discourse, these are the two words that came mainly from Michael Foucault's influence on legal and social theory. Power, not just domination or coercion, but the networks of influence that shape how people think, speak, and act. Power doesn't merely enforce truth, it produces it. Discourse, the structured ways of talking and thinking that define what counts as knowledge, reason, or legitimacy. For example, legal reasoning. Objectivity, crime, property, these are all examples of discourse. Law itself is a discourse, a specialized language that frames reality in particular ways. So together, power and discourse both together shape what a society calls truth. Critical legal thinkers argue that truth in law isn't discovered or described neutrally. It's constructed through social and institutional practices. Let's take these examples. The legal category of property presupposes a worldview where ownership and exclusion are natural. But that's a discursive construction, not a timeless truth. Legal definitions of crime, family, or rationality, they all reflect the dominant class, gender, or cultural perspective, which law then reinforces as universal truth. Thus, law is not merely a mirror of reality. It's a machine for producing reality, defining who counts as rational, credible, or deserving. Critical legal scholars sought to expose these hidden structures of power and to deconstruct the idea of neutral objective law. They emphasized 1. Law as ideology, a system that masks its political foundations. 2. The instability of legal meaning. Texts and precedents can always be interpreted differently. And 3. The embeddedness of law in race, class, gender, and economic power relations. So law doesn't discover truth. It creates it through language, authority, and institutions. What society takes as true or just is often the result of who has the power to define it. So let's contrast with earlier traditions. Common law, source of legal order, has been reasoned observation of experience. For positivism, it has been systematic human legislation. And for critical legal thought, it is power and discourse. For common law, the method has been induction. For positivism, the method has been description. And for critical legal thought, the method is deconstruction. For common law, the truth model is truth discovered in human practice. Positivism's truth model is truth established by logical coherence. And for critical legal thought, the truth model is truth constructed by social forces. So critical legal thought argues that law's truths are not neutral or objective, but products of power embedded in discourse. By shaping how we speak and think about justice, law participates in constructing the very reality it claims to govern. Karl Popper, the philosopher of science, rejected the idea that knowledge could ever be certain or final. Instead, he proposed a critical evolutionary model of knowledge. We never prove theories true, we only test them and falsify those that fail. Knowledge advances not by verification, but by error correction. So truth for Popper is provisional, a horizon approached through criticism, not a static possession. So this is often called falsificationism or critical rationalism. This was Popper's core insight. The Popperian insight is that human knowledge is fallible, but we can still make progress by institutionalizing open criticism, transparency, and error correction. This transforms truth-seeking from dogmatic certainty into a process of continual self-correction. So in short, the rationality of a system lies not in being right, but in being open to being shown wrong. So law, like science, aspires to truth, justice, and order, but must do so under conditions of uncertainty and fallibility. Popper's model offers a powerful analogy. It says, hypotheses are tested by falsification, knowledge grows through criticism, no final truth, only provisional models, and institutions protect criticism, free inquiry. Whereas law, legal arguments are tested by adversarial challenge, justice evolves through open dispute and precedent, no perfect law, only revisable rules and interpretations, and courts protect dissent and appeal through due process. So we see that a Popperian legal order is one that embraces critique as its method of self-correction. So this insight resonates legally because 1. It justifies the adversarial system as a structure of critical testing, not moral combat. 2. It grounds judicial review and precedent as mechanisms of falsification and refinement. 3. It supports constitutional openness. Law must be revisable and subject to reasoned criticism. And 4. It warns against legal dogmatism. No rule or ideology should be beyond review. So it turns law from a system of certainty, a positivist dream, into a system of critical resilience, one that learns. So in summary, the Popperian insight that truth emerges through continual criticism and correction, not through certainty, has profound legal resonance because law too must remain open, self-correcting, and falsifiable if it is to stay just. Science has long been law's mirror. This means that law has often modeled itself on science, taking cues from how science claims knowledge, organizes reasoning, and legitimizes authority. From the Enlightenment onward, jurists sought to make law rational, systematic, and empirical, just as scientists sought to make nature intelligible. So law reflects science not only in method, but in self-image. Both see themselves as objective disciplines capable of discovering truth through reasoned procedure. In this sense, science is not merely an analogy for law. It is law's epistemic mirror, its way of seeing itself as part of humanity's rational order. Both law and science aspire to stand above bias, passion, and prejudice. Science claims objectivity through controlled observation, experiment, and replicability, and law claims objectivity through procedure, precedent, and reasoned justification. In both, the idea is that personal belief should yield to methodical reasoning. In science, the method replaces faith, and in law, due process replaces arbitrary rule. So this shared claim to objectivity gives both their moral authority, the public's trust that decisions are not just power but reason. Both build systems from observation. Here lies their structural kinship. Science observes the natural world and generalizes laws of nature. And law observes social life, disputes, customs, harms, and generalizes rules of conduct. In both cases, observation to pattern, pattern to general rule, and general rule to prediction or decision. That inductive logic binds them. Both believe that careful observation of reality can yield stable, generalizable principles. That's exactly what early common law judges and early scientists shared: empirical rationalism. Neither science nor law grounds its authority in divine command or inherited tradition. Their legitimacy comes from how they reach conclusions, from their method. Science says, trust me because my results are reproducible by anyone who follows the method. And law says, trust me because my judgments arise from a transparent, reasoned process anyone can follow or appeal. In both, method replaces metaphysics as the source of legitimacy. They are procedural truth systems. Their credibility depends on disciplined process, not sacred origin. So when we say science has long been law's mirror, we are recognizing a shared modern faith that truth, order, and justice can be constructed through reasoned observation and disciplined method, not revelation or authority alone. So this is the Enlightenment's legacy to both fields: rational objectivity as the foundation of legitimacy. So in summary, law and science are parallel enterprises of modern rationality. Each seeks objectivity, constructs systems from observation, and justifies its power by appealing to method rather than command. Law, in looking to science, sees its own aspiration to turn reason into justice through disciplined procedure. For as long as people have tried to explain the world, they have borrowed from science to explain society. Law is no exception. The rules that govern human behavior have always been shaped by the rules we thought governed nature. When the universe looked mysterious, law was mystical. When the universe looked orderly, law tried to be orderly too. The great turning point came with Isaac Newton, his Principia Mathematica. Published in 1687, it gave us a new way of seeing the universe. He showed that the motion, the falling of an apple, the orbit of the moon, all of that could be explained with a few clear principles. His famous formula, F is equal to mass times acceleration, that meant that every push or pull, the force acting on an object with mass, would change the movement in a predictable way. Suddenly the universe looked like a machine, precise, reliable, and above all deterministic. So if you knew the forces and the masses, you could predict the future. This worldview transformed philosophy, politics, and law. Jurists began to think about human responsibility the way Newton thought about physical motion. If a person caused harm, that harm could be traced back along a straight chain of events, just like a ball rolling after being struck. Causation in law, the idea that one act leads to another, became a mirror of causation in science. You can see this inheritance everywhere in legal theory. Take causation itself. Courts ask whether a person's act caused another's harm. That is the legal equivalent of asking whether a force caused a change in motion. Take corrective justice. When one person wrongfully injures another, the law restores balance by requiring repair or compensation. And this mirrors Newton's third law. Every action has an equal and opposite reaction. Even utilitarian theories of law, which try to maximize social welfare, they rely on Newton's determinism. If actions produce predictable consequences, then a judge can add them up and choose the best outcome. So in short, Newton gave laws more than metaphors. He gave it a structure, a worldview. Legal reasoning adopted the clarity, linearity, and determinism of physics. For centuries this worked. If a carriage driver struck a pedestrian, causation was straightforward, the driver's negligence caused the harm. If a merchant sold spoiled goods, responsibility was clear. If a builder left scaffolding unsafe, the chain of causation led directly to injury. So law functioned as a Newtonian machine, apportioning blame along clean lines. But this framework depends on three assumptions: that causes can be isolated, that responsibility is singular, and that outcomes are predictable. Autonomous and distributed systems undermine all three. Take the autonomous vehicle. A collision occurs. But why? Was it the sensor that misread the object? The algorithm that classified it? The safety driver who failed to intervene? The corporation that set the parameters? Each factor contributed, but none alone is the full cause. The Newtonian chain fractures into a web. Law, as inherited from Newton, is not built to handle this. Proximate cause demands a single actor. Corrective justice demands a clear counterforce. Utilitarianism demands predictable consequences. Retributive theories demand a guilty mind behind the guilty act. But autonomous systems blur, distribute, and probabilize responsibility. The same happens with distributed systems. A swarm of drones follows simple local rules, but collectively produces complex and sometimes dangerous behavior. So who is responsible if harm occurs? There is no central controller, no singular act, only emergent outcomes. Or consider distributed artificial intelligence, trained on massive data sets across networks. If bias appears, is it the data, the model, the designers, or the users? The answer is all of them and none of them. The Newtonian framework collapses. This is not simply a legal crisis, it is a crisis of thought. Law has always borrowed its concepts from science, and the science it borrowed, Newton's mechanics, is no longer adequate for the systems we must now govern. But as science has always done, law too can evolve. Physics did not stop with Newton. It encountered anomalies. Black body radiation, the photoelectric effect, the behavior of atoms, that Newton's determinism could not explain. Out of these anomalies came quantum mechanics, a new framework where probability, uncertainty, and entanglement, they replaced certainty, linearity, and singularity. So quantum mechanics does not destroy Newtonian physics, it extends it. Newton still governs the planets, bridges, and carriages, but at small scales. In complex systems, Newton fails and quantum takes over. The same must happen in jurisprudence. Newtonian causation will still suffice for simple cases. The careless driver, the negligent builder. But for autonomous systems, drone swarms, distributed AI, and emergent algorithms, we need a new jurisprudence. One that borrows from quantum theory, maybe. Here is the insight. Responsibility in such systems is not singular, but superposed. Not linear, but entangled. Not certain, but probabilistic. Before judgment, responsibility exists like a quantum state, spread across multiple actors, each both responsible and not responsible. The act of adjudication is the act of measurement, collapsing the cloud into a determinate outcome. This is no way a metaphorical flourish. It is a structural parallel. Just as the wave function assigns probabilities to outcomes, so responsibility can be assigned as probabilities of contribution. And just as quantum mechanics accepts uncertainty as fundamental, so jurisprudence must accept that we cannot have perfect certainty in complex distributed systems. To cling to Newton here is to cling to illusion. To move to quantum, maybe, is to acknowledge reality. This is where we stand at the end of the first part of our exploration. Newton gave law its structure. Autonomous and distributed systems now expose the cracks. Quantum theory offers the vocabulary of probability, superposition, and entanglement. Law must borrow again, as it always has. And in the next movement of this lecture, we will see how this shift changes not only doctrines like causation and liability, but the very foundations of justice itself. So when we speak of justice in law, we usually mean one of a few great traditions. Corrective justice, which seeks to right wrongs. Distributive justice, which seeks to allocate goods fairly. utilitarianism, which seeks to maximize welfare, and retributivism, which seeks to punish wrongdoing in proportion. So each of these traditions arose in its own historical setting. Yet, each carries within it the stamp of Newtonian determinism. Corrective justice is perhaps the most Newtonian. Its basic principle is balance. When one person wrongs another, the law restores equilibrium. The wrong is the action, the remedy is the equal and opposite reaction. If a careless merchant sells rotten goods, the buyer is compensated. If a reckless driver harms a pedestrian, the driver pays damages. The symmetry is exact, echoing Newton's third law. So this vision depends on determinism. For the scales of justice to balance, we must be able to identify the wrongdoer clearly, isolate the act precisely, and connect it linearly to the harm. Corrective justice assumes that cause and effect in human affairs are as predictable as cause and effect in physics. But when harms arise from autonomous systems, the symmetry falters. A self-driving car strikes a pedestrian. Was it the sensor's fault? The software's? The corporation's oversight? The regulator's laxity? There is no single opposition reaction to restore balance. The scales of justice tilt under uncertainty. Corrective justice, modeled on Newton, breaks down. Distributive justice also inherits Newtonian clarity. Its central idea is that social goods should be allocated fairly. Aristotle spoke of geometric proportion, each to their due. Later thinkers built systems for distributing wealth, opportunity, or rights. The assumption beneath these theories is stability. If society is ordered like a Newtonian machine, goods can be distributed predictably, rules applied uniformly. But distributed systems destabilize. When algorithmic platforms allocate visibility, opportunities, or credit scores, outcomes are not stable but emergent. Bias creeps in. Feedback loops magnify inequality. Distributive justice built on proportion finds itself chasing a moving target. Fairness in the deterministic world is one thing. Fairness in a probabilistic world is another. Utilitarianism, too, presumes determinism. Jeremy Bentham's calculus of pleasure and pain requires that consequences be predictable. If one act produces more happiness than another, then we can choose rationally. The whole theory rests on the predictability of outcomes, as if human affairs were as measurable as physical forces. Yet, autonomous and distributed systems often defy prediction. A small change in code can cascade into vast and unintended outcomes. An adjustment to a platform algorithm can alter markets, politics, even culture. The utilitarian calculus collapses not because the principle is false, but because the world is no longer deterministic enough to allow the math. Retributive theories of justice finally rest on the notion of moral desert. Wrongdoers deserve punishment proportionate to their guilt. This assumes that guilt can be isolated and measured like force on an object. A person acts, an outcome follows. Punishment restores moral balance. The Newtonian picture of linear causation underlies the moral clarity of retribution. But in distributed harms, guilt is diffused. Who deserves punishment when harm is emergent? The programmer who wrote the code, the company that deployed it, the regulator who approved it. Each bears some relation but none alone. Retribution struggles to find its target. The Newtonian clarity of guilt blurs into quantum superposition. So what then does quantum thinking offer? Corrective justice in a quantum key becomes probabilistic correction. Instead of a single action and reaction, we have a spectrum of contributions. Remedies are distributed across entangled actors, proportional to their probabilistic responsibility. Balance is restored not through one-to-one symmetry, but through allocation within uncertainty. Distributive justice in a quantum key becomes adaptive allocation. Instead of assuming stability, it recognizes flux. Fairness is measured not by static proportion, but by resilience under uncertainty. If systems shift, justice shifts with them. Distribution becomes dynamic, responsive to emergent patterns. Utilitarianism in a quantum key becomes expectation-based. Instead of predicting certain consequences, it works with probabilities. Acts are judged by expected values, not certainties. This does not eliminate rational choice, but reframes it. Choices are made under uncertainty, outcomes weighted by likelihoods, policies designed for robustness. Retributivism in a quantum key becomes entangled accountability. Instead of isolating guilt, it recognizes shared entanglement. Punishment may still be proportional, but proportional to entangled contributions, not singular acts. Accountability is collective, not individual alone. So seen this way, quantum thinking does not abolish classical theories of justice. It extends them. Just as quantum physics does not erase Newtonian mechanics, but refines it. So quantum jurisprudence does not erase corrective, distributive, utilitarian, or retributive justice. Each remains valid where determinism still holds. But in the domain of autonomous and distributed systems, where uncertainty and entanglement reign, they must be reframed. This reframing is not trivial. It challenges centuries of legal and moral context. The law has always premised certainty, that cause could be found, blame assigned, and justice done. Quantum jurisprudence insists that certainty is sometimes impossible. Justice then must be something else. Fairness within uncertainty, accountability within entanglement, and balance within probability. This is the great shift. To move from Newton to quantum is to move from certainty to uncertainty, from singularity to entanglement, from determinism to probability. The theories of justice that guided law for centuries must evolve as science itself evolved. The true value of any legal philosophy is tested not in abstract theory, but in the world of actual problems. So yes, Newton's framework worked for centuries because life itself was mostly Newtonian. Actions were direct, causes were traceable, and responsibility was singular. But today, it's different. The disruptions posed by autonomous and distributed systems, they reveal the cracks. If Newton's causation is insufficient and if justice theories depending on determinism falter, how about a quantum-inspired jurisprudence? Let's see how that would respond. So let us examine some of the most vivid disruptions. Imagine an autonomous car navigating a crowded intersection. Its sensors detect objects, its software classifies them, its control systems decide when to brake or accelerate. And then an accident happens. A pedestrian is struck. The traditional legal question is simple. Who is responsible? In Newtonian terms, we would seek the driver, the singular force that caused the motion. But here the driver may not even be touching the wheel. The software made the decision, but the software is the product of a team of engineers. The engineers are guided by the corporation that sets design goals, and the corporation operates within rules set by the regulators. Responsibility is not singular. It is distributed, layered, and probabilistic. Each actor contributed, but none can be said to be the sole cause. So in Newtonian law, this situation produces paralysis. Courts may stretch doctrines of proximate cause, invent fictions of control, or impose liability arbitrarily. But these are patches on a broken framework. Quantum jurisprudence, by contrast, accepts that responsibility exists in superposition. Before adjudication, the engineer both is and is not responsible. The corporation both is and is not liable. And the regulator both is and is not accountable. The trial becomes the act of measurement, collapsing this cloud into determinate outcomes. The collapse is guided by probability, technical evidence about which layers contributed most, ethical reasoning about fairness in distribution, and systemic analysis of entanglement. Responsibility is not reduced to one party, but proportionally allocated across all. Now imagine a swarm of drones used for surveillance or delivery. Each drone follows simple local rules. Avoid collisions, maintain distance, adjust to neighbors. Out of these rules, global patterns emerge. The swarm follows like a flock of birds. If harm occurs, a drone strikes a person or the swarm crosses into restricted airspace, who is responsible? There is no central controller, no singular act of negligence. The harm is emergent, the product of decentralized interactions. Classical legal theory struggles here. Corrective justice assumes a wrongdoer. Utilitarianism assumes predictable outcomes. Retributivism assumes guilt. None can locate a center of responsibility. Quantum jurisprudence does not require a center. Responsibility is entangled across the swarm and its designers, deployers, and overseers. Each actor shares responsibility proportionally to their entanglement in the system. The harm is not reducible to one cause but distributed across the web. Now consider large-scale AI systems trained across vast, decentralized networks. Data comes from many sources. Training is distributed across servers worldwide. Outcomes emerge from statistical correlations too complex for any human to trace. If harm results, say a biased decision or a harmful recommendation, where is causation? Newtonian jurisprudence searches for the node, the single fault. But no single node exists. Bias emerges from entangled data, feedback loops, distributed processes. Quantum jurisprudence here recognizes responsibility as non-local, just as entangled particles remain connected across distance. Responsibility cannot be pinpointed in one node, but must be assigned across the entire entangled network. The law must treat the network itself as an agent, with responsibility distributed proportionally across its human and institutional components. Perhaps the clearest case is algorithmic decision-making in sensitive areas: credit, employment, parole. A risk assessment tool denies parole. A hiring algorithm excludes candidates. A credit model denies loans. Bias appears, yet no one intended discrimination. It emerged from data distributions and feedback loops. So classical jurisprudence asks, who discriminated? But no one did in the traditional sense. The harm is emergent, probabilistic. Corrective justice struggles because there is no wrongful act to balance. Utilitarianism falters because outcomes cannot be predicted deterministically. And retribution fails because there is no guilty mind. Yes, quantum jurisprudence reframes the issue. Bias exists in superposition, spread across data, design, deployment, oversight. The act of adjudication collapses this superposition into determinate remedies, proportionally allocated. So responsibility is probabilistic, entangled, and collective. Justice becomes adaptive rather than illusory. So, what do these stress tests reveal? Across these examples, autonomous cars, drone swarms, distributed AI, algorithmic decision-making, one truth emerges. Newtonian law is not failing because it was wrong, but because it was limited. It assumed singular causes, linear responsibility, and predictable outcomes. Autonomous and distributed systems defy those assumptions. Quantum jurisprudence offers not certainty, but structure within uncertainty. Responsibility becomes probabilistic. Causation becomes entangled. Justice becomes adaptive. The very act of legal judgment becomes an act of measurement, collapsing probability into outcome, guided by fairness, evidence, and philosophy. So this reframing does not weaken justice, it strengthens it by aligning law with reality. The world has become probabilistic, entangled, and emergent. Law must be the same too. We've walked far in this lecture, from Newton's clear lines of motion to tangled webs of autonomous systems, from the clean logic of classical justice to the blurred clouds of quantum jurisprudence. But the journey does not end in technical adjustments. It ends in philosophy, in rethinking what justice itself means when the world is no longer deterministic. For centuries, the legal imagination has promised certainty. Courts sought to identify the guilty party, the precise cause, the determinate remedy. Responsibility was singular, outcomes predictable, justice calculable. This promise was comforting. It aligned with Newton's universe. A world where if one knew the forces and the masses, the future could be predicted. But just as science had to surrender the dream of certainty with the birth of quantum mechanics, similarly, law may now think of surrendering it. The reality of autonomous and distributed systems proves that certainty in law is not always possible. Causation is tangled, responsibility is spread, and outcomes are probabilistic. The end of certainty is not the end of justice. It is the beginning of a more honest justice. For in truth, even in the age of Newton, law never fully achieved certainty. Proximate cause often disguised subjective policy choices. Foreseeability often rationalized hindsight. And the language of determinism gave the illusion of precision. But law, like life, has always been uncertain. Quantum jurisprudence does not create this uncertainty. It names it. It provides a structure for working with it rather than denying it. So what then does justice mean in a quantum framework? It means fairness within uncertainty. Corrective justice becomes not a precise symmetry of wrong and remedy, but a proportional adjustment within probability. If multiple actors contribute, each bears a share of responsibility corresponding to their entanglement in the outcome. Distributive justice becomes not static proportion, but dynamic adaptation. If resources and opportunities shift unpredictably under algorithmic systems, fairness lies in ensuring resilience and adaptability, not fixed distribution. Utilitarianism becomes not the maximization of certain outcomes, but the pursuit of expected value. Choices are made with probabilities in hand, policies designed to be robust against uncertainty. And retributive justice becomes not punishment of a singular guilty party, but accountability distributed across entangled actors. Proportionality remains, but proportionality to entangled contribution, not isolated blame. Justice, then, is no longer the restoration of a deterministic equilibrium. It is the fair management of probabilistic reality. This shift requires an ethical change. For centuries, law has claimed authority by claiming certainty. To acknowledge uncertainty is to acknowledge limits. But humility before reality is not weakness, it is strength. Ethics in a quantum age demands humility, the humility to admit that outcomes cannot always be predicted, that responsibility cannot always be singular, and that justice cannot always be precise. Humility does not mean resignation. It means designing law to be adaptive, proportional, and honest. Where classical jurisprudence sought perfection, quantum jurisprudence seeks resilience. Where classical jurisprudence promised certainty, quantum jurisprudence promises fairness within probability. So it is crucial to remember that quantum jurisprudence does not abolish classical law. Just as quantum physics did not abolish Newtonian mechanics, but extended it, so too quantum law extends classical law. For simple cases, the careless driver, the negligent builder, Newtonian determinism still holds. Classical causation still works, and corrective justice still restores balance. Retribution still fits guilt. But as complexity grows, as systems entangle, as outcomes blur, quantum jurisprudence becomes essential. Law must learn to shift scales as science does, from Newton to quantum, from certainty to probability, and from singularity to entanglement. Justice itself becomes multiscalar, sometimes precise, sometimes probabilistic, sometimes individual, and sometimes collective. The art of law becomes knowing which scale applies to which case. This is quantum horizons, not the end, but the beginning. A never-ending inquiry into how science shapes law, how law must rethink itself, and how justice evolves with knowledge. The epistemologies of relativity mark a profound reconfiguration in the architecture of knowing, where classical thought conceived knowledge as the accurate representation of an independent reality. Relativity introduces a relational epistemology, one in which truth, observation, and even ontology are functions of perspective. So today we trace the philosophical trajectory from absolute epistemology to relational realism, demonstrating its implications for legal cognition and the philosophy of normativity in the age of complex intelligence systems. From Descartes to Kant, epistemology was structured around the aspiration to certainty. The knower sought to secure knowledge on foundations immune to context, an Archimedean point from which truth could be measured against reality. Knowledge was conceived as representation, observation as passive reflection, and truth as correspondence. The Enlightenment's juridical counterpart was the ideal of the impartial judge, a rational observer applying universal norms to particular facts. The Cartesian subject thus becomes mirrored in the judicial subject, detached, neutral, and sovereign over the domain of knowledge and norm. This model presupposed a metaphysical dualism: subject versus object, reason versus world, law versus life. It yielded the epistemic virtues of clarity, universality, and necessity. But it also imposed the illusion that observation could be non-relational and that knowledge could exist without participation. Einstein's theory of relativity, special 1905 and general 1915, they introduced a decisive rupture in this metaphysical architecture. Space and time, once thought absolute, were revealed as contingent upon the observer's frame of reference. Observation was no longer a neutral recording of events. It was a relational measurement dependent on motion, velocity, and gravitational context. The epistemic consequence of this revolution is profound. Knowledge becomes conditional on the geometry of relation. No observation stands outside the system it describes. The universe is not a stage on which events occur, but a manifold of interdependent relations in which the observer is embedded. So truth, therefore, ceases to be absolute correspondence. It becomes covariant, invariant not by detachment, but by transformation. In physics, the invariant is the speed of light. In epistemology, it is the relational structure that persists across changes of perspective. The epistemology of relativity transforms ontology itself. The fundamental unit of reality is no longer the substance, but the relation. Entities are defined not by intrinsic properties, but by the networks of interaction in which they participate. This shift resonates across philosophy and science. In phenomenology, Husserl and Merleau-Ponty resituate consciousness as intentional, always directed toward and constituted by its objects. In quantum theory, Bohr's principle of complementarity mirrors Einstein's insight. Observation alters the observed. Knowledge is co-constitutive. In systems theory, Luhmann and Maturana conceive cognition as recursive relation, knowledge as self-reference within a communicative system. So we see that relativity is not merely a physical theory but a general epistemological orientation. The recognition that knowing is relational, participatory, and situated within the very fabric it seeks to understand. Relativity does not entail relativism. The confusion between the two obscures the depth of Einstein's epistemological innovation. Relativism dissolves truth into subjectivity. Everything is equally valid. Relativity, in contrast, introduces covariant objectivity. Objectivity preserved through lawful transformation between frames. What is invariant is not a fixed description, but the structure of relational consistency across transformations. In legal or ethical terms, this is akin to the idea that justice must remain constant across contexts, not by sameness of rule, but by preservation of equivalence under transformation. Objectivity in this sense is a dynamic equilibrium, fidelity to relational invariance rather than submission to an absolute vantage point. It is, as Karen Barrett later formulates, an intra-active objectivity, a product of relational entanglement that does not forfeit rigor. The epistemologies of relativity give rise to what can be called relational realism. Relativity exists, but only relationally. This is not social constructivism, which reduces truth to discourse, nor naive realism, which posits an independent world of objects. Instead, relational realism asserts that what is real are relations themselves, the invariance of interaction and transformation. So in this frame, knowledge is not a mirror but a mapping, a translation between relational coordinates. Every act of knowing reconfigures the relational field. Every observation alters the geometry of intelligibility. Relational realism thus underwrites a new epistemic ethic: humility before complexity, reflexivity in observation, and coherence across frames. It demands of the knower an awareness of the conditions of knowing, a second-order epistemic responsibility. Law as an epistemic enterprise has long retained the Newtonian ideal. Rules as fixed laws of motion, facts as objective data, and judgment as application of universals to particulars. But the world law regulates has become relativistic, distributed, informational, and observer-dependent. In a relativistic jurisprudence, facts are context-dependent articulations of evidence. Their meaning shifts with the interpretative frame. Justice must be defined as frame-invariant fairness. Fairness that holds under transformation of social, technological, or cultural coordinates. Constitutional principles function as invariants, maintaining coherence across frames of interpretation, like jurisdictions, times, systems. Judgment becomes a transformation operation, converting one normative frame into another while preserving relational consistency. Thus, the epistemology of relativity calls for a redefinition of law as a field of relational invariance, not as a code of absolute commands. The judge, like the physicist, must reason in terms of frames, metrics, and transformations, maintaining justice as an invariant under contextual translation. In the digital and cognitive age, knowledge is no longer localized. It is distributed across networks, agents, and algorithms. Artificial intelligence, multi-agent systems, and data-driven governance instantiate the epistemic logic of relativity. Each node perceives only from its own frame. Global coherence emerges only through transformation and translation between frames. So law therefore must evolve an epistemic infrastructure that mirrors this architecture, one based on interoperability of frames rather than universality of norms. Relational epistemology becomes computational epistemology, coherence through algorithmic covariance. This is the legal analog of Einsteinian symmetry, not sameness, but transformation, invariance. Once knowledge is recognized as situated and participatory, the ethics of knowing becomes inseparable from the act of knowing itself. In a relational epistemology, to know is to intervene. The observer cannot claim neutrality and thus bears ethical accountability for the epistemic effects of observation. For law, this entails a move from retributive or procedural responsibility to relational responsibility, distributed, networked, and co-constituted. Justice becomes the maintenance of relational coherence within and across systems of meaning and power. The epistemologies of relativity therefore inaugurate not only a new way of knowing, but a new way of caring for the integrity of the relational fields within which knowledge and law unfold. Knowledge in this way is not the possession of truth, but the preservation of coherence among truths. It is not certainty that grounds legitimacy, but the invariance of relational consistency under transformation. To think law, science, and ethics in the age of complex intelligence systems is to think in the language of frames, relations, and invariance, to replace the geometry of absolutes with the topology of coherence. In this sense, relativity is not a theory confined to physics. It is a general epistemology for a world that has discovered its own interdependence. Quantum indeterminacy signifies the deepest rupture in the history of modern thought. The collapse of the dream that nature, and by extension knowledge, is fully determinate. Where relativity dismantled absolutes of perspective, quantum theory dismantled absolutes of being. The quantum universe is not merely uncertain because of human ignorance, it is ontologically indeterminate, a world that exists in potential until interaction makes it actual. And today we explore the epistemological, ontological, and juridical implications of indeterminacy as the new paradigm of knowing and judging. From Newton to Laplace, modern science was built on the assumption that perfect knowledge of initial conditions entails perfect prediction of outcomes. Laplace's demon, capable of knowing all positions and momenta, could foresee the entire future of the universe. This determinist metaphysics grounded not only physics but law. Every act presumed a cause, every event a chain of necessity. Responsibility, guilt, and causation were modeled on the same logic. A closed causal order governed by certainty and predictability. Knowledge in this way was discovery of pre-existing truths, not participation in their formation. The world was a clockwork and knowledge was its mirror. In the early 20th century, Planck, Einstein, Heisenberg, and Schrödinger, they confronted anomalies classical mechanics could not explain, notably the behavior of light and subatomic particles. The resulting quantum revolution introduced the principle of indeterminacy. The more precisely one knows a particle's position, the less precisely one can know its momentum. Heisenberg's uncertainty principle in 1927 was not a technical limitation but an ontological statement. The world itself does not possess definite properties independent of observation. The act of measurement co-determines the state of the system. So reality at the most fundamental level is probabilistic, not deterministic, potential, not fixed, and interactive, not inert. Quantum indeterminacy reframes epistemology epistemology itself. Observation is no longer a passive recording of pre-existing facts, but an active event that collapses a field of possibilities into one actuality. This entails several key epistemic shifts. 1. Observation system entanglement. The observer is part of the system. Knowledge is co-created. 2. Probabilistic truth. Statements about reality are statistical. Knowledge is prediction of distributions, not certainties. 3. Non-locality and entanglement. Entities separated in space can remain correlated beyond classical causality. The spooky action at a distance. Einstein resisted, but experiments confirmed. 4. Collapse and context. Measurement actualizes one possibility out of many. Context defines the outcome. So knowledge thus becomes performative. To know is to enact. Epistemology turns experimental, an ethics of intervention rather than detachment. The quantum world resists classical ontology. Instead of discrete substances with fixed attributes, we encounter fields of potentiality, dynamic configurations of probability. Reality is not composed of things, but of events of becoming. Aristotle's distinction between potentiality, the dynamis, and actuality, the energia, returns in new form. The quantum world is pure potential until interaction. This is not epistemic relativism. It is ontological openness. The world itself is not fully specified until it interacts with itself through observation. In this sense, reality is self-referential, a continuous negotiation between possibility and manifestation. Quantum indeterminacy has produced multiple philosophical interpretations, each embodying a distinct epistemology. Let's understand the interpretation vis-à-vis the epistemic implication. The interpretation of Copenhagen by Bohr. The epistemic implication was reality is defined by measurement, complementarity governs truth. The interpretation of many worlds by Everett. The epistemic implication was all possible outcomes are real in parallel branches. Observation locates the observer's path. The interpretation of pilot wave by de Broglie-Bohm. The epistemic implication was determinism survives beneath apparent randomness. Hidden variables guide behavior. The interpretation of quantum Bayesianism by Cubism. The epistemic implication was probability reflects belief states of agents, not objective frequencies. Knowledge is relational trust. So despite their divergence, all interpretations agree that knowledge is inseparable from the conditions of its acquisition. Epistemology becomes entangled with ontology. Quantum indeterminacy implies a new mode of knowing. Knowledge as relational probability. Statements about likelihood within contexts, not certainties across universes. Truth as coherence among possibilities. Stability within indeterminacy. Objectivity as invariance of pattern. So reliability across observations, not detachment from them. So the epistemic virtue shifts from certainty to resilience of interpretation. The ability to sustain coherence amid uncertainty. Law's epistemic architecture, like classical physics, has been deterministic. It presumes clear causes, stable identities, and predictable consequences. But social, digital, and cognitive systems now operate in quantum-like indeterminacy, probabilistic, entangled, and context-dependent. So let's understand the quantum concept vis-à-vis the legal analog. The quantum concept of superposition, the legal analog is that the multiple potential interpretations coexist until judgment, like facts remain indeterminate until decisions. The quantum concept of observation or measurement, the legal analog is that the judicial decision collapses interpretative probabilities into binding precedent. The quantum concept of entanglement gives the legal analog that the legal outcomes across systems, like for example the jurisdictions, the algorithms, the ecologies, they all remain correlated beyond linear causality. The quantum concept of complementarity, The legal analog is competing legal truths, for example, equity versus rule, can both be valid within different observational frames. And the quantum concept of uncertainty principle. And the legal analog is that the precision in legal rule often reduces flexibility in justice and vice versa. So thus, law must evolve towards probabilistic reasoning, contextual interpretation, and entangled accountability. A quantum jurisprudence where knowing is participatory and outcomes are emergent. Quantum epistemology introduces an ethics of humility. If observation changes what is known, then judgment carries ontological consequence. The act of deciding is no longer the application of law to fact, but the production of a legal reality, the collapse of normative possibilities into an enacted world. Responsibility therefore extends beyond correct reasoning. It includes epistemic responsibility, awareness of how one's observation shapes what becomes real. And in the legal context, this suggests a transformation from procedural neutrality to reflexive responsibility. The judge, the legislator, or the algorithmic system must acknowledge their entanglement with the worlds they help to actualize. At its deepest level, quantum indeterminacy is not chaos, but ethical openness. It establishes the principle that the future is not given, but made through relation. Knowledge becomes stewardship of uncertainty, not its elimination. Ethical knowing is co-creation of possibility within the bounds of relational coherence. So thus, the indeterminate is not a flaw in knowledge, but its moral horizon, the space in which freedom, creativity, and justice emerge. Quantum indeterminacy completes the epistemic arc begun by relativity. Relativity abolished absolute frames. Quantum theory abolished absolute states. Together, they redefine knowledge as an adaptive negotiation between frames and potentials, coherence within uncertainty. For law, this signals the end of epistemic absolutism. The juridical act becomes a measurement event within a probabilistic field of meaning, a momentary stabilization of potentiality into actuality. Justice therefore must be reconceived as dynamic equilibrium, fidelity to coherence, not fixity. Responsibility within uncertainty, not control over it. The epistemologies of indeterminacy thus teach law, science, and philosophy alike that truth is not the elimination of doubt, but the disciplined inhabitation of it. Complex systems theory inaugurates a new epistemic horizon, one in which order arises from interaction, causation becomes distributed, and knowledge must account for emergence rather than control. It transcends both the determinism of classical mechanics and the indeterminacy of quantum phenomena, proposing a science of interdependence. This exposition traces the philosophical foundations of complexity, its epistemological implications, and its transformative significance for legal and normative reasoning in the age of dynamic, networked intelligence. The classical system conceived the universe as a machine, decomposable, predictable, and reducible to parts. Causation was linear, equilibrium was natural, and knowledge meant prediction. The failure of this paradigm in describing biological, ecological, social, and cognitive systems led to a new recognition that interaction among components can generate properties irreducible to the components themselves. Complexity emerges where systems are nonlinear, adaptive, self-organizing, path-dependent. Nonlinear, where small causes yield disproportionate effects. where feedback dominates prediction. Adaptative, where components modify behavior based on experience or environment. Self-organizing, where order arises without central command. And path-dependent, where history shapes current possibilities. Reversibility is rare. So this is not the physics of clocks, but of clouds, ecosystems, economies, and minds. In epistemic terms, complexity marks the end of the reductionist dream. Knowledge must now address wholes that are more than the sum of their parts. The ontology of complex systems is relational and dynamic. Entities are not substances with fixed attributes, but nodes in a web of reciprocal causation. Key ontological features include 1. The feedback loops, 2. Emergence, 3. Attractors, and 4. Edge of chaos. So let's understand these key ontological features. The feedback loops. Circular causality replaces linear sequence. Emergence. Novel properties appear at higher levels of organization that cannot be deduced from lower levels. Attractors. Systems evolve towards patterns of stability, strange attractors, equilibria, or periodic cycles that define their identity. Edge of chaos. Between order and disorder lies the zone of maximum creativity and adaptability. So reality itself is thus a process of self-organization, continuously negotiating between stability and transformation. Whitehead's process metaphysics and Prigoghine's dissipative structures, they converge on this point. Being is not a noun but a verb. Complexity requires a new epistemology. Neither the certainty of Newtonian determinism nor the probabilistic minimalism of quantum mechanics, but a processual epistemology attuned to pattern, adaptation, and feedback. The key epistemic shifts could be from prediction to anticipation, from control to coordination, from description to simulation, and from certainty to resilience. From prediction to anticipation, where outcomes cannot be precisely foreseen, one models tendencies and potential evolutions. From control to coordination, where governance occurs through modulation and feedback, not command. From description to simulation, understanding arises through constructing models that reproduce emergent behavior. From certainty to resilience, the value of knowledge lies in robustness to change, not closure. Knowledge in this frame is dynamic, recursive, and performative. It does not represent reality, it participates in its unfolding. Complex systems invert the second law of thermodynamics pessimism. While entropy increases globally, local order can spontaneously arise when energy flows through open systems. Ilya Prigoghine's theory of dissipative structures shows that far from equilibrium conditions can generate new forms of order, from convection cells to ecosystems to societies. Disorder becomes a precondition for creativity. Epistemologically, this means uncertainty is not a defect to be minimized, but a resource to be harnessed. Systems learn, adapt, and evolve through exposure to variability. Thus, knowledge becomes thermodynamic, sustained by energy, openness, and continuous renewal. Complexity science relies on computational epistemology, modeling systems through iterative algorithmic processes. The key frameworks include nonlinear dynamics, agent-based modeling, network theory, information theory. Nonlinear dynamics, mapping phase spaces and attractors. Agent-based modeling, simulating behavior of interacting agents with local rules. Network theory, analyzing topology, connectivity, and centrality in relational structures. And information theory, measuring complexity via entropy and redundancy. So each method reveals that macro patterns arise from micro interactions. Knowledge thus becomes bottom-up synthesis, not top-down deduction. Human cognition, economies, and legal orders are quintessential complex systems. They self-organize through communication and feedback. They maintain coherence through dynamic stability, not fixed equilibrium. They evolve through iteration and learning. In cognitive science, the predictive processing model frames the brain as a Bayesian engine minimizing uncertainty through feedback loops, an informational analog of thermodynamic homeostasis. In sociology and law, Nicholas Luhmann describes society as a self-referential communication system, autopoietic, meaning-generating, and closed yet adaptive. Complexity thus unites the epistemic, the cognitive, and the normative under one principle. Systems know by maintaining coherence in flux. Traditional jurisprudence imagines law as a hierarchical system of rules, whereas complexity reveals it instead as an adaptive ecosystem of norms, institutions, and discourses. The key reinterpretations here: 1. Norms as agents, 2. Legal evolution, 3. Emergent order, 4. Distributed causation, and 5. Nonlinearity. So norms as agents. Rules interact, reproduce, and mutate through application and precedent. Legal evolution, judicial and legislative processes form adaptive feedback loops. Emergent order, where legitimacy arises from coherence, not command, from stability under change, not rigidity. Distributed causation, responsibility diffuses across network of actors, institutions, and technologies. Nonlinearity, small interpretative shifts can produce systemic transformation, the jurisprudential bifurcations. So hence, law should be studied not as a static code, but as a complex adaptive intelligence, evolving through feedback, learning, and ethical constraint. Complexity enforces an epistemic ethics of humility. No model captures the whole. Every act of knowledge perturbs the system it describes. So thus the scholar, judge, or policymaker must cultivate reflexive awareness of their participation in the dynamics they seek to govern. Ethically, complexity demands adaptive responsibility, the continuous recalibration of action in light of feedback. Justice becomes an emergent property of the system's responsiveness, not a pre-imposed ideal. To govern complexity is not to master it, but to learn with it, an epistemic virtue of co-evolution. So complex systems theory reshapes the architecture of knowledge itself. Interdisciplinarity replaces specialization. Simulation and data replace pure deduction. Network epistemology replaces linear hierarchy. And ethical responsiveness replaces normative absolutism. So knowledge becomes a living ecology, evolving through recursive interaction among domains, agents, and technologies. In this view, universities, legal systems, and cognitive architectures are all meta-systems whose sustainability depends on adaptive coherence. Complexity completes the epistemic arc begun by relativity and quantum theory, where relativity taught us that observation is relational, and quantum indeterminacy that reality is potential. Complexity reveals that meaning and order emerge through interaction. It is an epistemology of becoming. Law, knowledge, and ethics are continuous processes of self-organization in open worlds. To think in complexity is to abandon the fantasy of final control and embrace the discipline of continual transformation, the jurisprudence of living systems.